Corpbiz.
Hello everyone, my name is Sushri Dash and I am here today to give you an overview of the copyright registration of music notation. So let's begin. IP or intellectual property is referred to the product of a human intellect, for example, technical, literary, artistic, or scientific work. When the legal rights are granted to the creators of these works, they are known as intellectual property rights, often referred to as IPR. These rights grant the creator an ownership and the exclusive authority to control and make the full utilization of their creation or invention. Some of the primary forms of the intellectual property rights are patents, geographical indications, integrated circuit layout designs and industrial designs, new species of plants and animals, and copyright. Okay, so for example, we all must have visited a club at least once in a lifetime. As soon as we enter that place, we all start enjoying to the popular movie songs. But are you aware that for a fact that these songs are being played in public, they need permission from the maker of the song? If not permitted, then one can easily be accused of copyright infringement. Firstly, let's secure a good grasp on the basic concepts. The definition of copyright. Copyright grants creators of original creative work the exclusive right to use further, authorize, and duplicate the material for the given amount of time, at which point the copyrighted item becomes a public domain. The term copyright has been defined under Section 14 of the Copyright Act of 1957. Chapter 4 of the Act talks about the ownership of copyright and the rights available to the copyright owner. Section 17 states that the author of the creator of the work is the first owner of the copyright. Now let's gain an historical perspective. The historical path of the copyright law in India can be traced back to its colonial era. The first ever Copyright Act in India was enacted during the region of East India Company. The Copyright Act of 1847 only provided the fundamental rights related to copyright. The Act of 1847 got replaced by the Copyright Act of 1914. It was the first modern copyright law in India because it was for the first time, all the works related to the work of literature were included under the ambit of copyright law. The Act of 1914 was then replaced again by the Copyright Act of 1957, and it was the first post-independence copyright legislation in India. The Act has been then amended many times since then. The most recent amendment was done in the year 2012. India is also the member of the Berne Convention of 1886 as amended in Paris in 1971, the Universal Copyright Convention of 1951, the Rome Convention of 1961, and the Agreement of Trade-Related Aspects of Intellectual Property Rights, which is short for TRIPS. Now, let's understand what are the works that are protected by the copyright law. As we all know that the creativity is the keystone of any society to grow and develop. Hence, no civilized society can afford to ignore providing basic requirements for encouraging creativity. The state has a duty to provide legal protection to the owners of creative work. With an increase in trade in modern world, we are witnessing more companies that are focusing on protecting their products of their brand from potential competitors in every way possible. But still, there needs to be more awareness related to the copyright and other related rights among the academics, communities, and stakeholders. Literary work is protected as per Section 2 Clause O of Copyright Act 1957. Similarly, dramatic work is protected under Section 2H. Work of architecture is protected under Section 2B. Work of adoption is protected under Section 2A. Artistic work is protected under 2C. Author is protected under 2D. And musical work is protected under 2P of the Copyright Act 1957. The Copyright Act 1957 governs the subject of copyright in law in India. Section 13 in particular talks about the scope of the act as well as the work that is included within. Section 13 in particular talks about the scope of the act as well as the work that is included within. It is very important to protect your creative work by registering under the copyright law. The registration will protect the owner's work from being copied or used by a third party for commercial purposes. Therefore, the copyright registration is essential in order to obtain a legal right over your creative work. Now, what are the rights of a copyright holder? Registering your creative work under a copyright law will grant the project to its owner as well as the representative of such work being copied or duplicated by any other third party. The creator of the work has all the rights to prohibit or authorize anyone to translate the work of the owner into some other language, to allow the third party to use the work for public performance, to make copies or record the work via making cassettes, discs, etc. The term of the grant of copyright. The term of the grant of copyright is for a lifetime of the author plus 60 years thereafter. The chapter 10 of the Copyright Act discusses the term of different copyrighted works. These are as follows. Section 22 of the Act talks about the term copyright in case of published literary, dramatic, musical or artistic works. Section 23 of the Act talks about the term for grant of copyright in case of anonymous or pseudonymous work. Section 24 of the Act talks about the term of grant of copyright in case of posthumous work. Section 26 of the Act talks about the term for the grant of copyright in case of cinematograph films. Section 27 of the Act talks about the term for the grant of copyright in case of sound recording. Section 28 of the Act talks about the term for the grant of copyright in case of government works. Section 28A of the Act talks about the term for the grant of copyright in case of public undertakings. Section 29 of the Act talks about the term for the grant of copyright in case of work of an international organization. Now that we are clear on the basics, let's move on to why copyright protection is needed. Here are some of the important reasons why a owner of the creative work needs a copyright registration. First and foremost, the copyright registration establishes a public record in all copyrighted work. So as soon as you complete the process of registration, your work will also be put out in public, letting everyone in the world know that you have claimed the copyright protection for that particular work. Copyright registration allows the owner to sue anyone for copyright infringement. Copyright registration, if done within 5 years of the creation of the work, will be considered as prima facie evidence in the court of law. Finally, let's discuss the documents required and the procedure for copyright registration for music notation. To copyright a song in India, the applicant needs to submit an application to the Copyright Office along with the following documents required for copyright registration for music notation in India. 2 copies of the original work, that is the graphical notes, name and address of the identity proof of the owner, incorporation certificate in case the owner is an entity. If the application is filled through an attorney, the specific power of attorney, which has to be original, duly signed by the applicant and accepted by the attorney. The NOC, that is no objection certificate from the publisher if the applicant is other than the publisher. An NOC from the author if the applicant is anyone other than the author. Now for the procedure. In case of music or song, copyright registration for music notation is essential. Also, it is very advisable since the industry follows a very common path of plagiarism and violation of author's right. Therefore, all music composers must register under the copyright law, which will provide them with a legal blanket to use, reuse and transform their work, and it will also offer royalties to them. The first step involves the search of copyright registration. The applicant has to perform a search in order to find if music notation of the same name or content or the same nature is already registered or not. The second step involves filing out a copyright application. The applicant is required to file Form XIV with the registrar of the copyrights along with the prescribed fee. The third step involves the publication of the copyright in the journal. The fourth and final step involves that the grant of copyright registration for music notation to the owner. So that concludes our video on the overview of the copyright registration for musical notations. For more such information and queries that you may have, contact Corpbiz from the details provided below. At Corpbiz, we have an excellent team of experts who can assist you as per your legal queries. You can also comment down below any of the questions that you may have. For more such video, subscribe to our channel. Thank you.